Module G, the facts. Remember the PASS acronym from a few of our previous modules? Well, we've covered P&A and now are moving on to the first S, selectivity. Once you've thought about the issues and done some of the research, then you can start thinking about which facts and events to select. A good story should set a scene and introduce the major characters. Think of the statement of the case as your opening. Use it to set this scene. To set the scene, you would answer, who? Who are the parties involved? What is the general area of law implicated in the appeal, and what specifically are the issues? Where has the case been so far? A trial court, administrative agency, or intermediate court? When was the alleged error committed? During pretrial, trial, or post-trial stage? And how? How was the case resolved? By summary judgment, a directed verdict, a jury verdict, or a non-jury award? First, let's look at what is considered to be more of a typical statement of the case. The parties in this action are plaintiff/appellant, Automotive Industry Supplier, Inc., herein, Automotive Supplier, and defendant/appellee, Independent Spring Manufacturer Corporation, herein, Spring Manufacturer. Spring Manufacturer is a supplier of spring components for the automotive industry. Automotive Supplier purchased springs sold by Spring Manufacturer and incorporated them into parts that it sold to Automotive Producer, Inc., herein, Automotive Producer. The springs failed, and, following a recall, Automotive Supplier brought this lawsuit against Spring Manufacturer, claiming breach of warranty, among other things. The Minnesota District Court for the First District correctly dismissed all of Automotive Supplier's claims against Spring Manufacturer because Automotive Supplier failed to comply with the notice requirements of Section 2-607 of the Uniform Commercial Code, herein, the UCC. Consider this ordinary statement of the case. This introduction systematically introduces the relevant parties and bores the reader to death because it fails to set the scene. There is nothing in the first 3 sentences here that even suggests what kind of case this is. Now let's consider an example of a thematic statement of the case. This is a case of commercial betrayal that illustrates the wisdom of the Uniform Commercial Code's notice provision in Section 2-607. Appellant Automotive Supplier is seeking in this action to recover over $10 million from a supplier of about $50,000 worth of springs used in automotive producers' vehicles. Automotive Supplier is pressing its claim even though it has never asserted, even at the Minnesota District Court for the First District, that appellee spring manufacturer defectively manufactured the parts. To the contrary, all parties agreed that the root cause of the problem with the springs was not some manufacturing mistake made by the spring manufacturer, but a design change that automotive producer directed. Automotive Supplier never once suggested that spring manufacturer was responsible for this design change until filing this lawsuit, 5 years after the problem was discovered and nearly 6 years since the time of sale. In contrast to the first example, which leads with party identification, as do most briefs, the second example starts with a colorful theme, commercial betrayal. This theme sets the stage for the action to follow, and it leaves the audience wanting more. This is not the time for elaborate character introductions or even rote summaries of legal arguments. There'll be plenty of time and pages to address such matters. Be selective about the material you choose to use in this most valuable space. Who? It answers the question, appellant automotive supplier and appellee spring manufacturer. What? Notice under the UCC, we're talking about springs and vehicles. Where? There's a nod to the Minnesota District Court for First District. When? The problem was first discovered 5 years ago, sale was 6 years ago. No exact mention to error, but alluded that it was not brought up before. In fact, it seems to be saying the error was never properly raised. How? It does not mention how the case was resolved at District Court. But overall, this still reads much more entertaining than the other. Not to say that the first one is wrong, simply that this one draws the reader in. Let's move on from statement of the case to talk a little more specifically about the facts. When it comes to the facts, it's all about the ABCs of legal writing: accuracy, brevity, and clarity. These are the 3 keys that you're going to want to build on. However, you don't want to sacrifice clarity for brevity. Be sure to limit your use of acronyms, therefore, so that you can be clear. You also want to make your facts statement as simple to follow as possible. This must mean that your facts must be reliable. It's about relevancy. To be relevant, you must include relevant facts. You'll also want to include copies of all relevant documents in the appendix. Do not rest solely on your pleadings. And it's important for you to think about what you're appealing from. For example, an appeal from an adverse summary judgment means that the statement of facts is even more crucial since material facts are actually in dispute. Always, always, always cite to the record. Every single sentence in your statement of facts must include a parenthetical reference to the record, such as Appendix 231 or Transcript 6. As I've mentioned before, this is about telling a story. As Slocum said, to read a story from the client's perspective, the reader must be able to sense somehow what the people in the story must have heard, seen, tasted, smelled, felt, and believed. The facts should be organized in such a way that they themselves show the theme so that you don't need to tell it. They should explain what the case is about. They should be persuasive without being argumentative. Persuasive writing is facts, not opinions. Do not become a salesman. Use your facts to advance your argument by pulling them together into a compelling story without slanting the facts unfairly. Sometimes, a good persuasive approach is to state the facts generally in the facts section and then provide more vivid details in the argument. This can give maximum impact to startling or shocking facts. Keep in mind, though, when you do this, the detailed recitation later in the argument section must include a parenthetical reference to the record if it's a brand new fact. The facts should also avoid characterization and interpretation. The court will be annoyed if you refer to your client as a poor widow, innocent of any wrongdoing, who was crushed by the greedy corporate defendant. Don't use highly connotative adjectives and adverbs. Focus on choosing the right nouns. Do mention that the defendant is a Dutch insurance holding company with $40 billion in assets. And after your first reference to the parties, appellant Robert Smith, don't use terms appellant, respondent, plaintiff, defendant again and again and again. Use the driver, Mr. Smith, her husband, or the injured employee. Pick one. Just be consistent in the use of the descriptions or names throughout. As you're telling the story, you need to make sure that it's a relevant story. Test every line and every fact as to the relevance in your argument. You probably won't repeat any dates of procedural steps from a statement of the case. Much of what has happened in the case is simply not relevant to the actual appellant issues. Discriminate between what is important and what is not. A good factual statement should contain every piece of information that the reader needs to know to decide the case or the issue, but nothing more. You also need to keep it interesting. Tell the story chronologically. Never ever recite the facts in order adduced at trial, witness by witness. You want to make the story as interesting as you can. Are you making the judges care about the issues? Sometimes, despite your best efforts to keep the story interesting, it will begin to bog down in technical detail. So simplify the story in the fact statement and save the detail for the argument. There is no requirement to recite every single relevant fact in the statement of the facts. Judicial opinions often begin with general statements of fact and then address precise factual details when discussing individual issues. Follow this lead. In preparing your statement of facts, and first and foremost is to preserve your integrity. Disclose what you should. Always include the facts that are favorable to your opponent if they are relevant. Do not allow your adversary the opportunity to tell the court that you failed to inform it of some relevant and material fact. Remember, you want the judge to adopt your statement of facts. Make your statement so carefully done, so scrupulously accurate, and so devoid of argument that the judge, even if he or she rules against you, will be comfortable adopting your statement when writing the opinion that decides the case. And be candid. If the court comes to doubt your candor in the process, your ability to persuade will be gravely undermined. Appellate judges have stated that an incomplete statement of the facts tells them that your case will be a loser when the whole story is known. Some judges say that an unfair statement will actually prompt them to prove the appellant wrong. Here is a sample statement of the facts. As you read this, think about who the writer was representing. Ask yourself whether this brief is for the attorney representing Prefect or Dent. On September 23, 2007, Ford Prefect was arrested without warrant on Highway X in Beetlejuice County by Officer John Marvin of the Beetlejuice County Police Department for refusing to take a breathalyzer test. Marvin took Prefect to the Beetlejuice Police Station booking room and transferred him to the sole custody of Officer Arthur Dent, who verbally abused Prefect with such invective as white trash, and scum. Prefect did not respond to Dent's taunts. After booking, Dent reapplied Prefect's handcuffs tight enough to leave bruises, and, despite Prefect's complaints, Dent would not correct the tightness of the handcuffs. The unreasonable tightness of the handcuffs was recognized by Marvin, who loosened the handcuffs upon returning to the booking room to find Prefect still complaining of the pain caused by the cuffs. Dent then transferred Prefect to the holding cell where, out of the sight of other officers or witnesses, Dent pushed the still handcuffed Prefect to the ground and struck him in the back with his knee, telling Prefect that he shouldn't have embarrassed Dent by complaining to Marvin about the handcuffs, and that Prefect would regret it if Dent had to return to the cell. Unable to cushion the blows with his hands due to the handcuffs, Prefect suffered a cut lip and bruised jaw from this attack by Dent. Out of fear of Dent, Prefect did not complain or request medical attention until he was sure Dent was off duty hours later. Upon complaint to another officer, Prefect was taken to Beetlejuice County Hospital for examination of his injuries.